Great. Thanks everyone for coming. Welcome to Can You Copyright a Vibe? A question that I'm sure haunts us all every day. I was asked to lead off by reminding folks that you should rate and review us in the DragonCon app. Give us 5 stars, nothing less, or we will find you.
We're taking notes.
Yeah.
Copyright you.
The more really good reviews we get, they can move us to bigger rooms and everything. It's great. I promise if you put down 5 stars now, we will make this a 5-star panel. We will adjust to the average rating as it comes in.
Oh, what's that a hidden threat? I like
It's a live responsive panel.
I like it.
So, we can just kind of go down the line and introduce ourselves real quick. I'm Meredith Rose. I'm a senior policy counsel at a group called Public Knowledge. We are a consumer advocacy org that works at the intersection of tech policy and consumer rights. We are currently in the federally occupied District of Washington, D.C., which is a hell of a place to be right now. We work on everything from, I mostly handle our copyright work, but we do competition and privacy and antitrust and First Amendment and you name it, spectrum policy, kind of on and on and on.
Excellent. My name is Andrew Greenberg. I am the executive director of the Georgia Game Developers Association. I make games. I'm a horrible programmer, but I do put on a convention called Transformer, all about game AI. We had the first one last year at Kennesaw State University. The next one will be in February of 2026. So if you're interested in games and AI, we had the head of AI for All Take 2 out at our last one. He had the most balanced presentation I've seen on Gen AI and general usage of AI in games. So check us out at ggda.org.
My name is TJ Mihill. I'm a business law and litigator with Stites and Harbison here in Atlanta, Georgia. I handle all kinds of business and IP, copyright, trademark cases. And I went to that conference and it was really good. I recommend you go next year.
All right, here's your money.
My name is Cory Rosenberger. I'm an assistant district attorney in the Conasauga Judicial Circuit here in Georgia. I've been practicing law for a little over a decade, specifically and solely in criminal law. I am not sure how I ended up on
My
this
kind of
panel.
code.
But I am happy to be included and share any insight if I have any. So,
You can give us litigation.
yeah.
The crimes here are mostly against good taste.
I'm Courtney Lytle Sarno. I'm a partner at Culhane Meadows. I also teach at Emory University Law School. I teach intellectual property and negotiations. I'm a transactional lawyer. No courtroom stuff for me. I've been working in the copyright area for way more years than I want to admit, looking at the audience, probably longer than the average age span here. But so I will be chiming in on that. I think that I will give a little bit of a short academic overview of copyright and trade dress.
Great. So show of hands, who here has read anything about the Sad Beige influencer case? Other than us on the panel, I presume we all did some homework. Okay, I got like one hand. Who here follows anybody that they consider to be an influencer on social media?
See, no.
Even the nerds count. Okay. So we're going to talk a little bit about this particular case that is the framework for this discussion. We'll get a little bit into detail about it, but the very high level version is we had sort of a copycat influencer situation where there is a particular woman who does a lot of clean girl aesthetic. Don't ask me what that means. It's beige. It's very aggressively beige. And there was another influencer who she apparently collaborated with once and then blocked her and then proceeded to do more or less sort of copycats of advertising the exact same materials in the exact same photo setup with these same affiliate links. There was some real kind of weird copycat behavior. This led to a lawsuit. And that's what we're going to be talking about today. So first I'm going to kick it all the way down to Courtney to talk about what does copyright actually protect before we start thinking about whether it protects this conduct.
Okay, so we have 2 different types of IP, intellectual property, that are relevant in this case. The first one is copyright. That's why we keep talking about it. It's actually in the title. The other one is going to be trade dress, which is a type of trademark. Both of those were alleged to be infringed in the lawsuit. Copyright is federally protected. It is meant to protect the creative expression, like books, like dance, like movie, like music. It doesn't protect any substance, and more relevantly for this, since I'm not sure there was substance, It doesn't protect ideas. So if any of you who are writers out there who have had really helpful people come to you and say, hey, we should work together because I have this great idea and all you have to do is write it. Any writers in the room are going, oh God, I hate those people. But so ideas are not protected by copyright. If I write a book about an ill-fated romance, on some level, I'm writing the same thing that Shakespeare did. Boy meets girl, things go badly. Whether everyone dies in mine or not, it doesn't matter. The idea is fairly simple. As you add details and expression and characters and dialogue, and hopefully a little bit more interesting than boy meets girl, things go badly, people die, you have different stories. Somewhere between boy meets girl and Romeo and Juliet, you have added enough expression that you can be protected under copyright. The basic idea is not. So if I draw a picture of a beautiful sunset, anyone else can go to that same place and draw a picture of the sunset. If I take a picture of a beautiful sunset, someone else who is standing next to me can take a pic, say, oh, what a great idea. I should take a picture. They can take a picture of that beautiful sunset. All they've copied is my idea. They didn't copy my photograph. I have rights in my photograph, but I don't have rights in the idea of taking a picture because it's pretty. So when we're looking at this case, a lot of it's going to be idea expression. But if you take a photograph, that's protected. If you write text describing something, your exact words are protected. There's more detail to it, but I think that kind of helps us for where we need to start with today. But so ideas are not protected, expression is, and nothing fundamentally useful is ever going to be protected in copyright. Only the way I describe things. If I make up a great process, or the classic case is an accounting process, first guy that came up with dual column accounting, great, he wrote a book about it. Several of his friends purchased it in case they had problems falling asleep at night. Someone else purchased it and said, oh my God, this is actually brilliant, and wrote up the exact same system that the first guy had invented. And there was no copyright violation at all because all he had copied was the process, the understanding, the invention. The substance isn't protected in copyright. We're going to talk about code a little bit, which is where this comes in and is a bit confusing because for reasons I have never understood, software is part of copyright. So software code is protected as a literary work. But wait, I hear you cry. I thought you just said that, functional things and indeed lists of instructions are not protectable. No, they're not. And yet, so the expression in code is protected. What it does and how it does it, which one assumes is the value, is not protected. Don't ask me to justify it. I would have voted against it. The other thing that we're going to talk about from an IP standpoint is trademark, specifically trade dress. Trademarks are specific things. They're the logos. You all know where I bought my thermos at everybody's happy place. Those of you in the back, it's Buc-ee's. The thing you can't see is what's in my thermos. This is better than a normal cup.
She didn't get it at Buc-ee's.
No, I didn't. So trademarks in general identify the source of a good or a service. If you have a white coffee cup with a green mermaid, I know where you paid too much for your coffee. If I have a red can with a white swoosh, you know which kind of cancer-causing caffeine I'm drinking. So that's what trademarks basically do. Trade dress is a little less, or it's a little squishier than just a trademark. Trade dress, Coca-Cola, the script, the color, and the swoosh, that's all a traditional trademark. The shape of the bottle, which really is just a pinched shape, it has nothing to do with the female silhouette, nothing at all, I tell you. The shape of a Coke bottle is distinctive and it identifies that it is a Coca-Cola bottle. That's trade dress. Trade dress, like trademarks, have to be distinctive and they have to be non-functional. So if there were a reason for Coca-Cola to have a female-shaped bottle, that made the bubbles more pronounced or less pronounced or something like that, it would not be eligible for protection as trade dress. Trade dress is something that helps you realize the more look and feel tells you where you are. If you opened your eyes suddenly and you were in a Starbucks, first we would have to talk about some of the earlier transporter panels and how we used one on you without telling you. But more relevantly, if you just glanced around, if you were suddenly in a Starbucks, you'd know where you were, whether you saw the word or not, right? The inside is distinctive. You know where you are. Apple stores, same thing. They all look alike on the inside. That overall look and feel can be protected. But like all of trademark, it has to be, as I said, both distinctive and non-functional. And I think that's, the one thing that I am supposed to hint us to that I didn't was when we're talking about copyright, when we're talking about things that are practical, things that are code, one thing that it does not protect is anyone's particular style. Now, style, my way of, if I'm a singer, my particular voice. Now, an individual recording of my voice will be protected. The way I sing, if I were a particular actor from a science fiction series in the 60s, and I talked a lot like this, most of you would know who I was. If my impersonation were better, all of you would have known that was William Shatner. But his way of speaking and adding punctuation where it wasn't, that's not protectable. It may be identifiable, but it's not protectable. Trademark will protect his actual name, image, and likeness. Y'all have heard that since we now pay our college athletes that. But just a general style is not protectable. In the past, there was really no call for that because someone like me doing a William Shatner impersonation really is no threat to his income. If anything, I would be threatening and that people might like him less because of me. But no one's going to mistake my bad impression or even someone's good impression for the original. Some of you have heard of artificial intelligence and that it can generate new things now. And one of the things that's now relevant is that it can copy people's style in a way that was never possible before. Copyright does not protect style. It protects specific expression, but not style, because it was just something that wasn't considered before. Now we're kind of considering it. And when we talk about copywriting a vibe, we have been joking up front saying, well, this will be a short panel because the answer is no. Seriously, we're done. Style is not protected, but not just because of people who like beige, but also when we talk about if AI can make a Shatner video without Shatner, maybe there should be something that the law will do, and copyright was just not set up to do that.
So this is a good jumping off point. I guess we can give this to TJ if you want to talk about what the actual content at issue is here and like what is the case that we're talking about?
Sure. So the case generally is two influencers, style influencers, as Meredith said at the beginning. And the case was brought on the grounds that a second influencer started using very similar backgrounds, very similar color schemes, very similar styles to sell products. In some cases, similar products. And the first influencer brought a suit to say, hey, you can't do that. Brought a suit for copyright, also listed trade dress and right of publicity. It got before a magistrate judge. There was some legal wrangling. The big takeaway is the case never actually went anywhere. The case was dismissed. It was not resolved one way or another. So there is no real answer to any of the stuff that was raised in the case. What gets people's attention is that it was moved beyond a motion to dismiss. So there's things there that would have gone forward but for the plaintiff dismissing the case. So that's why we're here to talk about what the situation is and what we have. And I think what we need to look at is exactly what Courtney just said. I think it was brought as a copyright case because a lot of people think of copyright as IP, as being one and the same, and lump all these things under the one umbrella of copyright. And here we don't have a copyright case. You can copyright a video. There could be a copyright claim over one of her influencer videos. There could be a copyright claim over one of her Instagram posts, still photos. But they'd be different than someone did one that looked kind of like it to do their own thing. You have to show that I copied it substantially similar to the image that was there, or that I used the same speech for the video, or something that was similar in a confusingly similar way for the copyright claim on that specific deal, that specific item. And what this case was about was, no, it's the whole thing. My whole page is beige. There's a reason we call it the sad beige case. And therefore, her whole page being beige violates my copyright.
I just, as a side note, I love the fact that her entire shtick is being the least distinctive thing possible.
Her entire house is beige.
Beige.
There's a few pieces of, I had to look at this. I'm like, I'm doing research on TikTok. Okay.
It's a horror story.
It's all beige with a little bit of pops of bright black. She has a baby. The entire nursery looks like all of the life and joy has been sucked straight out of it.
Which, not to get too off topic, like developmental psychologists will tell you is like the worst possible thing you can do for small kids.
They need
very
color
terrible
and contrast.
They need contrast.
Yes.
Also going to plug the Sad Beige TikTok account, which is actually just Sad Beige, which is a woman narrating like ads for beige kids' clothes in a really bad Werner Herzog impression. And it's these sad beige children do not know the joy in their lives. Which is like the entire, anyway, it's like my favorite TikTok account.
But it's interesting though, because that does make it hard. I'm about to tell you some things that you could do instead, which should have been argued. What could have been argued in this case is trade dress and rights of publicity. And what we have here, unfortunately, is probably not a very good case for either one of those either. No. Because trade dress is something that is distinctive and identifies you. Like Courtney said, you walk into a Starbucks, you know you're in a Starbucks. You've all driven by the used to be a Pizza Hut.
Yeah, that's an excellent example. We all know what it was. It's still a Pizza Hut.
Then it's the accountant now. There's an H&R Block in there. That's a Pizza Hut, and we all know it.
I saw one that's a Domino's pizza.
That's good branding.
I thought that was brilliant.
But that's what trade dress
intentionally.
is. We know it. We see it. We know what I'm going to get in that building. Maybe not now, because maybe it's an accountant, but it would have been a Pizza Hut. And that's what makes trade dress. It's uniquely identifying your goods and services. And sad wall of beige. I just don't think you can make a very good argument that I'm the beige one. Now, in terms of your social media, if you are the only one on social media who is trying to be so sadly generic, unlike everyone else who's trying to stand out and make a name for themselves and be bright and colorful, you might have a trade dress argument that I am the only person this boring on TikTok. And in that case, maybe you can make a trade dress one. But that's what trade dress would be. But that's what would protect this kind of thing. Your background isn't something that is going to be a copyright claim, especially when your background doesn't really have anything in it.
Especially since she was not the only one doing it. If you look at the specific facts, the defendant in this case did copy some of her stuff. There's just too many similarities to think that she didn't look at it and say, ooh, I'll do something similar. But she did something similar. She never actually copied it exactly. She did copy the beige colors, but it was pointed out to me in some of my field research. I asked my son and his friends who are crashing on my floor, since they're much more the target demographic than I am. One of the Kardashians, and I remember to say it with an SH rather than make it Star Trek, one of the Kardashians was all into that too. She wasn't trying to sell cheap crap on Amazon, but she would do tours of the house and it was beige. I mean, like aggressively neutral. And so these girls didn't even invent it. It was there already.
Okay, so
I am told.
You can't copyright an aesthetic. So
Correct.
we pretty well established that. You start to get into weird sort of liminal spaces around your identity as a person.
Mhm.
So I'm actually curious, Cory. I'm going to make you work for being on this panel.
All right.
So if you actually look up this case and you look at the photographs, they do the filings have side-by-side photographs of the original woman's influencer A's post and then influencer B's post, and they have a series of these, and they are kind of uncanny and frankly, like, to use a term of art, they're a little creepy.
They did not make me want to go to Amazon.
Yeah, no. So I'm curious, what we talk a lot in the IP space about things like name, image, likeness. Outside of that, if you have somebody who's genuinely trying to impersonate another person online, what are the legal implications of if she had changed, say we had a slightly different fact pattern, she changed her username and said, I am now influencer A, you sort of have this fake mock-up account that is either reposting her content or posting stuff that is uncannily close to it.
Right.
What kinds of legal implications would that have, if any?
In the criminal sense, I don't think that would have any. I don't think that would be a crime.
Mhm.
I think that there would certainly be civil implications from it. Identity fraud. Generally, you have to steal some sort of identifying information, kind of like the copyright. You have to use it exactly. So if I wanted to steal some money from Mark Zuckerberg, and I somehow got his social security number. That would be the identity fraud in there, is actually taking that specific thing. And so I don't believe that unless you are copying it exactly, which I don't think you can do on TikTok, I don't think that would specifically be a crime. Now, any states can make a whole lot of different things a crime. I am familiar with Georgia law. I practice in Georgia. California, New York, a lot of the states where, this is a lot more popular, there are a lot more people whose business is entertainment, it might be a crime out there. But as far as Georgia, it is not.
All right. Andrew, I'm going to kick it over to you as well because you've been sitting here so patiently.
Well, I would love to tie it over to GameStop because
Absolutely.
these are the kind of things that really do impact us. You don't realize that until too late. So one of the things that is not copyrightable is a game mechanic. Thus, classically, we had Pac-Man and Munchman. Amazingly similar, but you could not copyright the game mechanic. It had to be the specific expression of it and then the trademarks for the name and so forth. This is also why you saw so many Flappy Bird spinoffs just a few years ago. Besides the guy being from Vietnam, you couldn't copyright what they did. Oh, I think we'll do questions in a bit. But we'll often be fighting over then the expression thereof. We've seen these battles come up in the game industry quite a bit. And I really want to go ahead and throw this out on another twist, which is how some game companies have gone to protect their game mechanics. And I know we've got a few Magic the Gathering players in here. So what Magic the Gathering did, WotC, back when they were still an independent entity, was to patent tapping. So if you don't know this, actually turning a card sideways is patented. And apparently the office found it patentable, has been fought in the courts yet. So it's very interesting that how you try and copyright those, how you try and protect those aspects that aren't copyrightable. And I've actually been involved in these on the code side. I was had a publisher called New World that would give code out to the developers or independent studios. Say, hey, if you want to fix it, we developed this code. You can use it and modify it as long as you're being published for us. And one of the other studios we were associated with then went out and tried to use this code in a game from somebody else. And that's when suddenly there was an action to be had. Not that there was similarities, not that their mechanics were the same, but New World had actually given them code, and now he was trying to use that with a separate publisher without having had permission to do so. So these arguments go far beyond just the influencer community very easily, and there's a reason we all keep an eye upon these.
So one way in which this expands beyond just the influencer community, I think, one way to kind of conceptualize this is copyright in particular. And I'm going to pick on copyright because that's, A, it's in the title of the panel, and B, it's the one that I deal with at work. So copyright is generally designed to protect a specific work. So as Courtney pointed out, it's designed, say you have a photo, right? It is designed to protect that specific photo. If somebody, does something that shares one element of that photo, it's probably not an infringement. If they start taking 2 or 3 or 4 or 5, at some point you start tipping into a space where, as people, we start to get kind of uncomfortable with it before the law starts to get uncomfortable with it in a lot of cases. And we're seeing this happen a lot right now in the fights around generative AI. Especially around artists and the concept of style and whether style is protected. So I'm going to put to one side because I don't want to turn this into a Gen AI panel because we will be here for 48 hours fighting about it minimum. But to cabin it off to one side, and let's set aside the whole training data, whether that's a fair use question, but we're just talking about if I had a robot, beep boop, and it can output perfect imitations of Jim Davis's work, and it can just start generating what looks like a new Garfield comic. He has a very distinctive style. It's not actually outputting an existing Garfield comic. It's not outputting characters that are recognizable from the Garfield comic, but it looks like a Jim Davis cartoon. People are very uncomfortable with that. Do folks want to talk about how the law does or does not cope with that?
Well, yes, but I want to lay out one more thing first because this is my favorite thing to tell people. Because when you come to me, you usually don't want to find this out for the first time. What Meredith just said is that copyright protects an image, a video, photo, whatever. It's all true. It protects that from the moment it is created. The minute you click the shutter on the camera, that photo is a protected, copyrighted work. And then you come to me because somebody has absolutely and without a doubt copied that work and made $1 million off it. And I say, okay, give me the registration and we'll go get you your money. And you say, what? And then I say, okay, let's go try to get your registration as fast as we can. It will cost you about 20 times as much. And by the way, you've lost the right to statutory damages. So
You won't get as much money when we win.
right. So copyright exists from the moment of creation, but copyright law really only protects a registered work. So when you have somebody who's putting out like an influencer account, just reams and reams and reams of video, not all of those are necessarily copyrighted either to begin with. So you need to look at that before you can think about what can I bring a suit on? Because without a registration, that's the key to the courthouse door. All I can do is write a nasty letter. And I'm good at nasty letters. But nasty letters can go in the trash and I can't do anything about it. You want me to send a marshal to their house and make them come to the courthouse, I've got to have a registration.
In this case specifically, generally none of them register their stuff because they generate so much of it, and these people are not necessarily known for traditional details and work ethics. But she did, after the dispute started, the plaintiffs actually started registering her videos and her pictures. So she talked to a lawyer somewhere, I assume, because I can't imagine she figured it out for herself, she said scathingly. But for a while there, she was actually registering everything with that idea that she wanted to be able to enforce it. So for the bulk of her work, she would have gotten your unhappy face. But for most of the more recent stuff, it was, she actually was doing the right thing and registering it. The other little copyright quirk that can apply is that even if we end up, remember I was saying I'm on the beach, I'm taking a pretty picture of a sunset, and the person next to me says, oh, cool idea, I'll do that too. Takes out a phone and takes, with my luck, a better photograph of the exact same thing. They copied my idea, they didn't copy my photograph. So even though our two photos are probably identical, there's no copyright violation. Independent creation is not infringement, unless you're a former Beatle. But so if these two women came to the same idea of let's be aggressively neutral and dull, they each are allowed to express that, even if they end up with the same expression, so long as they don't copy each other. Now, in this case specifically, there was a fair amount of anecdotal evidence that the defendant was pretty blatantly copying a lot of and getting her ideas at least from the first woman. But not, except for the late registrations, there weren't any.
Now, I meant to also answer your question, but I'm covering.
So let me jump on it though, if you don't mind. So we've got this AI bot doing Jim Davis. We'll call it Tron Davis. So Tron Davis is now turning out these bad Garfield ripoffs. The issue that Tron Davis has is those are not copyrightable at all because it is not an expression of a human. It is an AI expression, and you cannot protect the AI expression. So one of the things you're hearing right now that's a concern for this AI generation generated materials is that they are not copyrightable. Now, however, and so you see all this AI generated art, and the reason games don't put it in is they can't protect that. I could, if they put that in Helldivers, I can snatch that from the Fading Suns in a heartbeat and put it in. I couldn't copyright it either, but they couldn't come after me for something having this Helldiver art in my game. However, to keep twisting on this, there's a group here in town, I had them at the Transformer Conference, Invoke AI, that does have a copyright now for AI generated art. And Kirsty's done a great job. And it is about the human involvement in the AI process. And I'm not going to spoil what he loves to talk about with his stuff, but we do a video on our Georgia Game Devs YouTube channel, so you can check that out. Georgia spelled out Game Devs. But Tron AI, or Tron Davis, is not protected, and that's the problem for that creator. If that influencer is starting to generate AI art, I can snatch that from my more popular channel and put it there freely and be getting views off of what they created using their prompts.
Yeah, it is completely unprotected.
Yeah.
How would the audience know it's an AI work?
So this is the part where I'm going to make myself a panelist for a second. So a couple of things. One is that AI, again, sort of as we mentioned, style is too amorphous to be protected under copyright. And there are good policy reasons for that. One of which is if you've ever gone, if you have, who here has actually taken like art class in their life? Okay. Who here as part of that art class had to sit and copy paintings that you saw in a museum? Okay. Part of learning how to do art is to copy the work of other people. This is historically, we just have always, this is how people learn how to art, is you copy the styles of other people, and it is still a very popular thing to do. We copy the style of like Alphonse Mucha, who did all this beautiful Art Nouveau advertising posters from the late 19th century. The other thing is that copyright is designed to protect the work of human beings. It is not designed to protect, and if you want to get into the history, you can go all the way back to the fights around cameras. And when cameras were first introduced, there was a big dust-up about whether or not photography was artistic, or whether you were just pushing a button, getting a slavishly mechanical reproduction of the world as you saw it. Copyright, we have in fact, plus the Copyright Office, they have had to deal with a whole lot of weird stuff. It does not protect selfies taken by monkeys. Sorry, and the monkey's name was Naruto. Let's just keep that out. It does not protect works written by ghosts. See, people actually tried to register something saying that they were taking dictation from a ghost through a planchette. It's a real thing. It does not protect works written by the Holy Spirit.
Yep. Driftwood is right out.
Yep. It does not create, and it does not protect works created sort of by random chance, like random scatter art. We can get into a fight about whether or not
Painting elephants, no copyright.
But so when you have a human prompting an AI to output something, you can ostensibly protect the bits of it that were created by the human, and you have to divide what came from the AI and what came from the human. Now, this is a colossal migraine. There's no good way to do it yet, but that's where the law sits right now. And it's actually, I'm a policy person first and foremost. I think that's actually a pretty good policy, especially if you want to encourage, you can frame it two ways. You want to encourage human artistry or discourage the mass adoption of AI as a worker replacement. Kind of either way, it's pretty good that we don't. I personally think that we don't.
We agree on a policy too.
What's that?
I think we just agreed on a policy.
Shit. Fire exits are that way.
Sometimes we agree on what the law is, but I don't think we've agreed on what it should be before. But
Might be.
I'm frightened.
We all agree that termination rights suck, or they're broken. Anyway, so we're at, I think we are at a good place to start taking questions, including vibes-based questions. We'll take vibe checks, high vibes, low vibes.
Line up at the mic. Watch out for the fire
Vibe checks or traditional paper checks. You'll take those too.
And don't do that fire exit joke. At the end of our OnlyFans panel on Friday night, the fire alarms did go up just as we ended, so we were too hot for the hill.
It was just as.
Hello, I have a question. Shouldn't AI be considered random?
Ooh, that's a good question. Shouldn't it be considered random? Well, it's about as, I mean,
You can continually get very similar responses, so you've got a range of that random. So yes, it's just trying to find the next word in the series, and it's going for what the most likely next word in the series would be. So, I mean, it's not true randomness. Ain't nothing in computers is true random.
Right.
Let's just move that.
it's replicable.
Yeah,
to some
replicable.
extent,
So,
yeah.
I
mean, it's random in the sense like Photoshop filters, right? Or they do kind of predictable things when you tell them to do things, and we are in a weird space right now where there are kinds of art that are still largely computer enabled, like a lot of modern Photoshop, a lot of modern filters are like very dumbed down versions of what or rather AI is like hyper upscaled. We can question whether it's still dumb or not. Versions of tools that are already baked into a lot of modern artistic processes, like music production, auto-tune. That is fundamentally a machine learning tool. And so this idea of like, when you use auto-tune, we don't think that's enough to knock that part of the work out of being protectable by copyright. But if you start using like the Suno platform, where you like type in a prompt and it just generates a song, that's too much machine and not enough person. And we're in this weird transition state of trying to figure out exactly where that line is. And trust me, if anybody can answer it, please like tell me and we'll become immediately rich.
I wanted to just provide some pushback that game mechanics aren't copyrighted and bring up games like Osu and Beat Saber. Because those rhythm games, the music is an instrumental part of the game and it's copyrighted. And you can't really play the game without the music. It's such that it's an intrinsic game mechanic.
Well, the music can be copyrighted.
Yes.
The idea of having a game where I've got to slap something when something happens is not. If I've got to, wave my hand this way, it's not any different than Guitar Hero pushing the button. It's just a different representation of that mechanic. But the music is certainly copyrightable. Some of the images that you're using may be copyrightable. But the idea that a song is going to play and at certain points in that song you are going to make an appropriate gesture is never something that's going to be protected.
pushing the button at the right moment. Yeah, not protected.
And then I had a question. Oh, so how can you prevent someone from making false claims? For instance, on YouTube, it's an epidemic, or at least it has been an epidemic.
Yeah, for moderns
of
now.
false claims and people making claims on behalf of other people that didn't even know the claims were existing. I've seen claims on music, like a DJ makes a song, posts it on YouTube, and then it gets copyright strike when he made the song. Like it wasn't a remix, it was like an original song.
Yeah, so one of the fun things about, and I'm saying fun very sarcastically, in case you can't tell, is this is like, this predates AI, but it's algorithmic sound detection, right? So sound fingerprinting. We see this actually, the example I like to use is classical music. So during the pandemic, there was this sort of movement where a lot of classical musicians, like symphony orchestra types, would live stream largely on Facebook. Of them playing from their homes, and they would be playing like very well-known classical pieces, public domain pieces. They would get flagged and taken down because the difference between a copyrighted recording, like a recording that was made of Bach or Beethoven, a recording that is under copyright because it was made yesterday, versus somebody live streaming. Those differences are very tiny, and algorithms are very bad at separating those two things. But it's an example of how we've kind of like automated detection on these very large platforms. and the end result is that, sometimes it's malicious intent. Sometimes the takedowns are just keep my name out of your mouth or, screw you. Sometimes it's just robots are stupid, and they have tin ears and they're going to flag stuff that they don't actually have the right to flag.
And I had a fascinating experience in that the music in my game, Remember the Fading Suns, I have it up on my YouTube channel. YouTube knows that it's mine, no problem. I've never registered with YouTube saying, go after people for this, but I'll get notifications when streamers are playing my game. Hey, your music's in this game. Do you want to register a complaint? It's like, no. Go. But I haven't told YouTube I want them to. They're just coming to me. And it's so easy to hit that button and say, sure, you said bad things about my game.
Well, that's it. It's over aggressive policing, but it's over aggressive policing because what allows YouTube to be YouTube or any other site that allows user generated content to have user generated content is that there is a protection in place that allows them to not be sued for what's on their platform. But in order to not be sued for copyright infringements on their platform, they have to follow the DMCA takedown process. And if they get a takedown, they have to take it down. And if they get a put back, they have to put it back. They don't have an option in that. It's not an alternative. If they don't do that thing, they're the one getting sued for copyright infringement. And trust me, every lawyer in the world would much rather sue YouTube than you.
One trivia fact, they actually don't have to honor putbacks. Twitch does not. Just straight up, Twitch for a very long, they have changed this, but for a very long time they do not have. So the only insulation they get, and this is very lawyer inside baseball. So if the requirement that they take stuff down, if they get a copyright notice, they have to take stuff down. That's to prevent them from getting sued by the copyright owner.
Right.
If they, when they get a counter notice to get it put back, that's to prevent them from potentially getting sued by the person who had uploaded the content. And a lot of platforms have said, what the fuck are they going to come after us for?
So
They just decide not to honor it.
So they just ignore
They
that
just ignore
part
it.
of
It's
the
just
DMCA
gone.
because they're not afraid of small people.
Yeah, it's like functionally unenforceable.
How much is the damage going to be? Because you want.
Yeah.
Yeah, because you deprive me of
Yeah.
some.
Don't sue the poor as day one in law school. Don't be afraid of being sued by the poor as graduate work.
It's there was an attempt once years ago where somebody attempted to go after, I think it was Twitch, because they didn't honor putback notices on the argument that you wouldn't put my stuff back, and so I missed a ton of revenue out of this. What the hell? And it just kind of evaporated. So,
Couldn't that become a class action?
in theory.
Because that would make people frightened. TJ, are you busy next week?
Go for Amazon.
Find some of our friends from
I'll write the brainy part, the academic MBA part.
There you go. I'll yell.
There is a famous piece of intellectual property case law from the 1980s that feels like it is relevant to this discussion, and I'd like to unpack it a little bit from the experts, and that is Fogarty versus Fantasy, which for the uninitiated is when John Fogarty's former record label sued him for sounding too much like John Fogarty. Now, Fogarty did prevail in that case, but it did go all the way to the jury. And it just feels like there are implications there that are worth talking about, and I'd like to hear your opinions on that.
Who's John Fogelberg? Sorry.
Ask your parents.
I use the music from that case in my copyright class frequently. And none of my students, when I first started teaching copyright, I'm not going to tell you how many years ago, there were always a few students who knew the music. And now there are none. So I always had to shush my students, say, and if you know why this is an interesting case, shut up. Remember, I'm grading your exams. I will go after you. And they don't say anything. And everyone's like, oh, wow, they sound really alike. And the chord progressions are the same. There's always one music student in my class. And the voice is the same. And that's where I go, well, wait, what if I try to copy your voice? And I've often used that case to express exactly that I don't have a right to the sound of your voice, but if you're copying someone else's sound recording, that's a different issue. But it's his voice, and no one owns his voice, including him. That case was interesting because Fogarty basically, when he was part of CCR, like most musicians, they got ripped off by their management company and the record company, so he didn't own the rights to his records. And so he made a new one. And I got to admit, when I'm kind of fast forwarding through to play between the two songs, it's Old Man Down the Road and Run for the Jungle. Man, those sound alike. I mean, I know both songs fairly well, and parts of the musical part in the middle, it's like, wait, which one is this? So they do sound a great deal alike, but a lot of the similarity is because the same guy wrote and performed them. The reason, and that was one that really would sort of turn on style, but you couldn't really argue as much that he copied the previous work, because that's just how he wrote. But if he didn't copy the previous work, it wouldn't be infringement. But most people who are excited about that case, which is a very small subset of a very geeky part of the law world, most of us think the reason he actually won that suit, I mean, quickly and close to unanimous, I think, if not very close to it, is because he showed up at trial with his guitar. He played for the jury. So Fogarty came in and did a lovely concert for the jury, and apparently is a charming individual.
To ask the pointed follow-up question then, might it have turned out differently today?
So this is great because Taylor Swift straight up re-recorded her masters.
Yep.
I thought, whatever you think of her, I thought that was brilliant.
That was incredible. Okay, so music.
I loved that about her,
agree?
nothing else.
I know.
Well, we always do. I love things like Taylor Swift.
Yeah, the little things like
Little
Taylor
things
Swift.
are easy.
I had promised myself I was going to avoid thinking about Taylor Swift all weekend. And then she went and got engaged. Yeah, so
Really, she did? I hadn't heard that.
I don't know. Some jock.
Oh.
So yeah, so
Captain
Taylor
the football
Swift.
team?
There are okay. So zooming away, I'm going to keep this as brief as possible. When you think about a song, there's actually two different copyrights going at play, and it makes sense if you think about it historically. Before we had recorded music, as we know it today, we had songwriters. They came first, so there was a songwriter copyright in the you think about it like the music on the page,
Yeah,
right?
sheet music.
Sheet music, and then there's a different copyright in the actual recorded version of that song. Now, Taylor Swift is the songwriter and the recording artist in most of her cases. Her masters, which are basically the rights to the sound recordings for her first handful of albums, there was some drama. They ended up in the hands of Scooter Braun, who sucks. She hated him, and basically out of sheer spite, went through and re-recorded entire albums and re-released them as Taylor's version. Now, she did this for a bunch of reasons, one of which was to screw over the original version on the algorithms on Spotify, so that it would deprive Scooter Braun of any of her money. You know what? And I will stand a spiteful queen. That was incredible. She could do that because she was the songwriter, but these two recordings are not indistinguishable in a lot of cases. If Scooter Braun had wanted to sue her for infringing on a recording of herself, he probably could have done it, but he didn't because she's Taylor Swift.
But if she didn't change it, she's just doing a cover of the original composition and has to pay the mechanical license, which is trivial. She would be paying herself the mechanical license
And
because she owns the composition.
And she could use the statutory, so in the law, it says, by the way, as a songwriter, you cannot deny somebody the right to record a cover of your song, basically.
It's compulsory.
It's a compulsory license. If someone wants to cover your music, you have to let them do it by law.
If you don't change it. If they're going to change it.
It has to remain as faithful to the original as possible.
And she made hers faithful to the original,
Literally
so it's a
identical.
cover.
So, anyway, sorry, music nerd out.
Did we know if she paid herself the compulsory license? I think she's required to.
Probably. Give yourself a pat on the back.
Well, I mean, everyone in between would take money from the compulsory license before she got her penny, but, so I assume she did.
All right. So I thought the concept that a game mechanic can't be copyrighted was interesting, and I wanted to ask about the Pokemon Pal World lawsuit. Because when Pal World came out, a lot of people thought, "Wow, this is stylistically very similar to Pokemon. It has a lot of the same mechanics." People called it Pokemon but with guns.
That's terrifying.
But in this lawsuit that Nintendo brought up, honestly, I don't know how much of the litigation is happening in the U.S. versus in Japan, I guess. But Nintendo seems to be having some success in this lawsuit. They've gotten Power World to change some of the mechanics, like the Pokeball mechanic. I think you used to like throw out your Pokeball and release your pal, but they got them to change that. So where is this success coming from?
Well, right, that's what we're looking at. It's the same answer as to what would actually happen on that Tron Davis Garfield case. We can sit here and have fun academic discussions about copyright all day, but that's never going to see the light of day because Garfield's trademarked. So if you have patents on something, Magic's tapping system, you can stop people from using that aspect of the game mechanic. It's not a part of the copyright, but you can stop someone from copying that patented element. You can stop someone from copying your trademarked element. Or in the case of publicity, to kind of bring it back to the last one, someone using your identity, your voice, your identifiable publicity elements, if you're in a state that allows that.
Okay. And we've got an interesting one coming up in the game industry that might be a topic for next year, which is where one company pitched a sequel to another, got rejected on the sequel, and now they're releasing themselves, but very clearly all the elements of the sequel are in there. Hey, we're going to see this one coming to court in the not too distant future.
Thank you. So I want to ask you a question about what you think the law should be here. So when you mentioned something like Crappy Birds, I personally think, something like that shouldn't really get to exist. Like it's too close to the thing. But also then there's a question of the line of how much are you stifling creativity with those type of laws? So where do you think that line between protecting an artist and not stifling creativity should lie? Not where it does lie.
So as someone who's come up with a lot of game mechanics and honestly has ripped off some other people's game mechanics to do it, I'm very glad that I can do that. I will not deny there's plenty of Shadowrun in Vampire and plenty of other games in my Fading Sun stuff. So I like where it is right now. I like being able to do that and then have my setting, my specific expression thereof.
I will say that historically we're in a weird position. Like right now, the way that we sort of commodify and make money off of art is a historical anomaly, right? Like if you go back far enough, like people have always made art, but even setting aside that, people have been professional artists. You went through all kinds of models of like, you had the Medicis, they just kept bards on retainer, all these different kinds of funding models. But like fundamentally what has not changed is the way that people create, and that's by ingesting the art of people who came before them. And so there's organically a lot of recycling. Like we tell the same stories, we use the same formats, and copyright law recognizes that, right? There's all kinds of carve outs for things like the fancy French term sense affaire, which is, tropes. You can't protect a trope. Like it's part of human storytelling. We tell the same stories. And so I think the law tends to err more on the side of people are going to recycle other people's stuff to some extent. Now that comes into tension with the fact that we're living in a sort of capitalist hellscape and it's impossible to feed your family as a working artist. But that's a bigger question that I think copyright is capable of dealing with. And it seems like to the extent that any dust has ever settled on copyright, that's mostly around the point at which it's settled.
A question so you mentioned you can't copyright a vibe, etc. But you can copyright a character. James Bond, etc. Would she have been able to have an argument that like she was embodying a fictional character of her creation, and that was the copyright that was violated?
Wouldn't have had to admit that it actually is sort of like wrestling. Capital Wrestling had a bit of a moral crisis for a while when they were trying to protect their purely scripted characters and outcomes and everything. I mean, I'm sorry if I'm going to break someone's heart, but wrestling is fake. It's scripted. I'm sorry. I probably shouldn't have done those. We're on the late night panels.
I'm going to get you steal.
Yes, but if we're both trained, it won't hurt at all. But they couldn't protect a copyright in any of their storylines or choreography or anything until they admitted it was fake. Because if it was sport, there's no copyright in what happens when baseball players play, one assumes. At least they're still playing. But in most of sports ball, it's sports stuff. And so there's no copyright attaching to it. In wrestling, it clearly is not actually that. Sure, they're athletic, but they had to admit that it was fake in order to sue for infringement, which they did, and successfully. But this the same thing, you would have to get these girls to admit they were fake, but that's the perfect segue to one thing that my field research suggested to me as I was asking my, cynical Gen Alpha kids that were sleeping on my floor for the next few days. I was asking them about this case, and all of them, after telling me that no, none of them actually look at women who have beige houses and sell baby furniture, since one of them was my son, I was pleased. He needs to finish school. But they said, oh, well, it's probably fake anyway. Half the time when these people sue each other, it's just for the publicity. And I'm like, oh my God. I'm like, I'm so proud of my child. He's grown up insanely cynical, and so are his friends. I'm so proud. But I just thought that was an incredibly interesting take because, I was given this topic, I started churning into it. I'm looking at the cases, I'm looking at lawyer stuff, and the mouths of babes came, oh, it was probably fake anyway.
So I think we got time for one more question.
Oh, explain that. Really just dismissed it.
Yeah, that's why, she ran out of money is not hard to imagine. You know what litigators charge.
Yeah.
But I just thought it was so funny. That was their first thought after I ran names by them. They're like, who?
So going back to the Power and Pokemon discussion, my understanding was they retroactively went back and added the patent of capturing or throwing a captured monster out. So the Power World implementation was you just kind of like let the thing out at your side now. So my question is kind of at what point can these bigger companies retroactively go back to any kind of game and claim that they were the ones who originally had the patent on it, because they made the patent after Power World was released.
So I don't know anything about the patent case, so I have no insight on that. But patents, you can only patent something if the patent office is actually paying attention. You can only patent something within a certain time after it's been disclosed to the public.
Right. So after you release it, there's a limited period of time that you have to patent it, and if you don't patent within that limited window.
Okay. So you can't do that retroactively after.
You have to.
Okay.
Tapping didn't get patented until years after Magic was a successful.
I didn't say they always enforce their rules, but the rule is that, the patent office, they patented swinging sideways on a swing set. The playground lady yelled at you for doing that. Well, now the patent office can come after you for it.
Great.
It's honest to God in the patent.
Go forth and infringe. All right. Well, great. Thank you, everybody, for coming out.